to be addressed.
I call the Honourable Member David Clendon. Tēnā koe.
Mr Speaker, I'm pleased to take the opportunity for the first time to speak to this bill. The Green Party's view on this proposed legislation, was formerly represented by our now departed colleague and friend Keith Locke, departed in the parliamentary sense, of course, but I am pleased to pick up the cudgels from Keith and to endeavour to do at least half as good a job as he had done on this, what is a very complex and far-reaching piece of legislation. It's to be acknowledged, as has been, that the committee clearly has taken its responsibility seriously. I don't know how often committees open up for second rounds of submission. Clearly this committee chose to do that, to its credit. I think if one looks at the list of submitters, the depth and the quality and the range of the submissions that were made, largely in opposition to the original draft of this bill, I think we can see there very clearly why the step was made to have a much closer look. And it's generally, we will acknowledge that the committee process has delivered a better bill, but still not one that is sufficiently advanced that we can support it. We still consider that this bill, on the whole, represents a major erosion of civil liberties. We do not concede that the extreme steps taken in this bill are warranted in the current climate that we have in this country, and we will continue to oppose this bill. Sir, there are a number of examples, a number of issues, provisions we could take. I'll focus on just some of the more serious, and clearly the issue of examination and production orders come to the fore in that list. These are clearly a violation of a traditional long-held right to silence, a right to people not to speak, with some exceptions. There are virtually no exemptions in this bill. People who may be required to give evidence against a suspect could be close family members, friends, spouses, civil union partners, people living in the nature of marriage. We believe that that spousal relationship or its equivalent, there's an integrity, almost a sanctity to that relationship that ought to be recognised and honoured. It is unacceptable that a spouse can, in this legislation, be obliged to give evidence against their partner in ways that could give them, that could lead to prison sentences, or it's compromising a relationship that ought not to be compromised by anything we do in this House. It's unacceptable, and we would continue to argue strongly against that. We're concerned similarly that production orders can be enforced by a whole host of state agencies other than the police, customs, or indeed the Serious Fraud Office. It's instructive to look at column 2 of the schedule, and just to start ticking off the number of individuals, the various officers, appointees of a whole host of government agencies who would have the power to enforce these orders. We think it goes far too wide. It will enable all sorts of abuses. It will almost invite abuse by agencies who the average New Zealanders would think have no part investigating the privacy or compromising the privacy of New Zealanders. We note that some of the offences that where an examination order may be deemed appropriate include such things as intentional damage. Now, intentional damage, it's not desirable that people damage property, but however, these charges of intentional damage are often linked to civil disobedience, to peaceful non-violent protest in the course of appropriate and people asserting their right to protest. Intentional damage is not an uncommon charge that is brought. And while it's fair that people should suffer the consequences if that is deemed to have occurred, we don't believe that in that context a person exercising their right to protest should leave them vulnerable to these orders at a later date. And again, there seems to be no end point at which that liability to these examination orders would halt. The question of dissenting group who might be deemed by police to be an organised criminal group also opens the way for an examination order to be granted. Not wishing to comment on an issue currently before the court, but we're extremely uneasy about the apparent ease with which a group of individuals might be described or deemed to be an organised criminal group. We think that has yet to be tested by the courts, and we think it's a step too far at this point to have that as a provision of this bill. We're clearly, in this bill, the provisions of it move us much closer to what could be called a surveillance state, with extensive provision for visual, for audio surveillance, for tracking people, for intercepting their communications, for looking at their relationships, and we think that is many, many steps too far. There is simply not the need in New Zealand society for such extraordinarily invasive measures to be applied. We are concerned that judges will be given the power to issue warrants for as yet untried surveillance techniques or mechanisms. These novel forms of surveillance, not even perhaps yet developed or invented, dare I say. Is it conceivable we might have a monitoring device and disguised cunningly as a teapot, which would be acceptable at some future time? We believe that if novel forms of surveillance, of monitoring, of tracking are to be included in the arsenal of weapons, that matter should come to this Parliament. It should not be left, with all due respect to the judiciary, it ought not to be their role to make decisions which ought to be the domain of this Parliament, particularly given the severity of some of the sentences that are considered in this bill. It's evident clearly, the point is well made that some of the existing legislation that this bill seeks to amend or in some cases to repeal is sometimes 50 years old, and we know that technological advances have been extraordinary. We see technology advancing almost by the month, certainly by the year, and 5 decades is too long a time. That, however, does not in any way justify the provisions of this, but would enable the use of very easily concealed surveillance devices. Tracking devices now can be very small. Devices that can intercept people's communications equally can be very small and can be remote from the point at which information is found. Facial recognition technology, all of these technologies which arguably, yes, Parliament needs to have some serious thought about how we can manage the existence, the reality of these technologies. This bill fails to do that. All it does is seek to utilise existing and indeed yet to be developed forms of technology in ways which we do not think are acceptable in a free and liberal democratic state. I've made the point that we are very concerned that there is a very wide, in fact a very long list of state agencies who would be given powers under this bill. And it's important to note that very few of these state agencies have any forms of independent complaints authority. If a person has a concern with the actions of the police, for example, about whatever matter, then there is a clear line of accountability through the Police Conduct Authority. Any citizen can take a complaint to that authority with a fair expectation it will be heard. Many of the state agencies listed in this legislation, in this bill, have no such remedy for citizens who feel that their rights have been compromised or abused, and we ask the question, where are those people to go if indeed they feel they have been mistreated by these agencies? One of the most offensive surveillance warrants made possible by this bill are those that will allow state agents to trespass into a private home in order to insert surveillance equipment that can spy in people's kitchens, their bedrooms, their bathrooms. This is beyond the pale. People have a right to expect their homes to be inviolate. The notion of these only representing very serious criminal offending is not borne out by the fact that some of the provisions of this bill could be implied or imposed on people who have been found guilty of relatively minor offences against the Firearms Act. The Greens are no friends of weapons. We are on record many times as being very conservative on the availability and use of weapons, of firearms. But it's possible, for example, somebody found guilty of ownership of an air gun or a replica pistol, which are not desirable things indeed, but relatively low-level offending could nevertheless leave people vulnerable to this legislation. It is not necessarily legislation. That is not necessary legislation. We will oppose this through the progression through the House. Thank you, Mr. Speaker.
I call the honourable member Cam Calder.
Thank you very much.